decision on the matter that I understood to be before us, the narrow question that I understood to be before us, be helpful in any way if we do not peek at the merits and we also do not decide whether you have standing?
So I'm not sure how you could decide whether or not we got an appropriate scope of relief without figuring out what our own injuries are. Because how you decide, this is the United States' own argument, how you decide whether or not we should get relief for our own injuries turns on what our injuries are that require relief. And so I do think we have pretty significant pocketbook injuries, like in Nebraska, to the tunes of millions of dollars. And whether we get those remedies or don't get those remedied is going to turn on the merits, is going to turn on the nature of the harms, and then ultimately the workability of the alternatives.
Thank you, counsel. Justice Thomas? Justice Alito?
Well, General Sauer began by outlining problems that he sees being created by universal injunctions. And he said that the issue was a non-ideological issue and a non-partisan issue. Do you agree with that?
I do think presidents of both parties have objected to nationwide injunctions. I agree.
So what do you say about the practical problem? So let's put out of our minds the merits of this and just look at the abstract question of universal injunctions. What is your response to what some people think is the practical problem? And the practical problem is that there are 680 district court judges, and they are dedicated and they are scholarly, and I'm not impugning their motives in any way, but sometimes they're wrong. And all Article III judges are vulnerable to an occupational disease, which is the disease of thinking that I am right and I can do whatever I want. Now, on a multi-member appellate court, that is restrained by one's colleagues. But the trial judge sitting in the trial judge's courtroom is the monarch of that realm, and there are situations in which trial judges, the president does something. It could be President Trump, it could be President Biden, it could be President Obama. The trial judge says this is unlawful, and I'm going to enjoin it, and I'm convinced I'm right, so I'm not going to stay the injunction. And then an application is made to the Court of Appeals to stay the injunction. The Court of Appeals gives it the back of the hand, and then the case comes immediately to us in the context of an emergency application. And some of us have said, well, we don't think we should do anything in those situations unless it is indisputably clear that the court below was wrong. So what do you say to that practical problem?
So we're mindful of the practical problems. I will say the states have had a through line as well across administrations. We have never believed, even as nationwide injunctions restrained policies that we favored, that they were categorically off the table. We've always taken the position that they are sometimes available in narrow circumstances, whether we like the policy or don't like the policy. And so you might have some cases where the nature of the harm, this is the DACA example from my friend on the other side, where the nature of the harm, which was Texas saying it had to give benefits to residents in the state, is actually entirely remedied by a nationwide state-only injunction that applies just to Texas, because that might incentivize individuals to leave Texas, and then Texas doesn't have to give them benefits anymore. So you might have a case like that. But sometimes you are going to have cases where it is impossible to remedy the state's own injuries, and the alternatives are not practically or legally workable. And that describes this case perfectly. And so I don't think the answer is a bright line that means even in those situations, it's not possible for the states to get relief.
In deciding the question that is before us here, do you think we should, never mind, I withdraw that. I have no further questions.